but the idea is that we can discuss about the role of the International Court of Justice and what are the functions of the International Court of Justice, and specifically the contentious role of the International Court of Justice, since that obviously refers to what Jessup problems generally deal with. Jessup doesn't deal with advisory opinions. So the International Court of Justice, as you might know, is the principal judicial organ of the United Nations. It was created in 1945, and it's established by Article 92 of the United Nations Charter. So the creation of the court is established by the Charter, and if you go to Article 92 of the Charter, from Articles 92 to 96, that's where the court is regulated by the UN Charter. Now, although the court was created in 1945 through the Charter, the creation of the court was based on the Permanent Court of International Justice, which was created by the League of Nations after World War I, and which existed in the period between World War I and until the creation of the International Court of Justice. Now, it's very important for you to consider that the ICJ and the PCIJ, which is how we abbreviate the Permanent Court of International Justice, are related and are really a court. The ICJ is a court that comes immediately after the PCIJ. It's kind of its successor. You could put it in those terms. And that's very important in terms of the value of its jurisprudence. So when you're thinking about the importance of the jurisprudence of the ICJ, you have to also consider the jurisprudence of the Permanent Court. And the ICJ itself awards the same weight to cases decided by the ICJ or previously by the PCIJ. So there isn't really a difference in terms of ICJ cases having more weight than those decided by the PCIJ. So when you're thinking and when you're going through, the issues of the Jessup and thinking generally about international law, just consider that your job doesn't really start in 1945, with the creation of the ICJ, but you have to consider what happened before. Usually the most relevant principles of international law, if you want to go to the very basic principles that govern the resolution of disputes, they're most commonly established in old cases by the PCIJ. So for example, if you want to determine the existence of a dispute, right, whether there is a dispute for the purpose of establishing the jurisdiction of the court, the definition of that comes from an old case called Mavromatis Palestine Concessions, which is an old PCIJ case. And from there, the court has built on subsequent jurisprudence. So it's important that you bear that in mind. Now, going a bit back to the ICJ, as the principal judicial organ of the United Nations, the Charter establishes in Article 93 that all members of the United Nations are ipso facto parties to the Statute of the International Court of Justice. What that means is that if you're a member of the United Nations, then you're immediately a party to the ICJ statute, and therefore you can appear before the court, you can bring cases before the court. And that's important to know because you don't need to then carry out any additional ratification of any other instruments. By the mere fact that you're a member of the United Nations, then you're a party to the statute of the ICJ. And because you're a party to the statute of the ICJ, you can then bring cases and participate in proceedings. So it's important for you to know just that there isn't any additional ratification requirements or signature requirements with respect to the statute of the ICJ, because the UN Charter would be enough in that sense. Now, there are certain mechanisms for states that are not members of the United Nations. They can still participate in proceedings before the International Court of Justice. For example, a state could sign and ratify the statute of the ICJ without being a member of the United Nations. Or even without ratifying the statute of the ICJ, they could also file a declaration, a unilateral declaration recognizing the jurisdiction of the court only for the purposes of a specific case. So there are options for non-UN member states to appear before the court, but obviously it makes it a lot easier if you're a member of the UN, because then that means that you can automatically appear before the court as being a party to the ICJ statute. So that's all in the Charter. The other thing that the Charter of the United Nations tells us is that UN member states undertake to comply with the decisions of the International Court of Justice. Now, this is in Article 94, paragraph 1 of the UN Charter, and this is the enforcement clause, right? This is what tells us that the decisions have to, that states parties have an obligation to comply with the decisions of the court. So, for example, in a hypothetical case, when you are asked how can you ensure that the state is going to comply, or how can you give any guarantees that the state you're representing is going to comply, which could be, for example, a Jessup mutable question. Well, Article 94, Paragraph 1 is always a good answer, because this is where you say, well, my state has a treaty obligation under the UN Charter, under Article 94.1, to comply with the decisions of the court, undertake to comply with the decisions of the court. So here you have the binding nature of the decisions of the court coming straight from the UN Charter. Now, Article 94, Paragraph 2 says that states can take recourse to the Security Council if they consider that the Security Council should take measures to ensure compliance or to give effect to a judgment. So this is the other side of the enforcement mechanism, which is what happens when a state doesn't comply. And if a state doesn't comply with a judgment, then the issue could be brought to the Security Council. The Security Council could adopt a resolution, and the Security Council and the resolution adopted by the Security Council could impose measures on a state that is not complying with a decision by the ICJ. So the Security Council has the possibility to adopt measures. Now, obviously, this has a political problem, which is the veto power by one of the P5 members, which could potentially create a problem for the Security Council to be effective when it comes to establishing to ensure the compliance of a decision by the ICJ. So if there is obviously a state that is not complying and that state is brought and a resolution is brought to the Security Council, potentially that a resolution could be vetoed and then the Security Council would be powerless to act. But I just want to say that this is more of it's an issue that so far has been more theoretical than practical, because in most cases, states do comply with ICJ decisions. And in some cases where states have not complied and the issue has been brought to the Security Council before adopting a resolution, before even putting a resolution to a vote in the Security Council, the states involved have been able to reach an agreeable solution. So there aren't a lot of cases where a state has brought the issue to the Security Council and a Security Council resolution has been vetoed by one of the P5. There is obviously one famous case, which is between Nicaragua and the United States in 1986, after the famous Nicaragua case. In that case, the United States did not comply, and Nicaragua brought the issue to the Security Council, and the resolution was vetoed. So in that case, there wasn't really any action that could be taken by the Security Council. Now, there's obviously a completely different question, which I'm not really going to address now, which is what happens with non-compliance of provisional measures ordered by the court. As you may be, following the work of the court has issued a lot of provisional measures in the last couple of years, especially in the last year. It has issued several provisional measures which relate to armed conflicts that are taking place in the world. And obviously, there are several questions with respect to compliance of those provisional measures orders. And what role can Article 94 of the United Nations Charter, and more specifically, what can the Security Council do in terms of compliance with those orders for provisional measures? Now, I'm not going to address that because that doesn't really touch upon issues that might be relevant in your Jessup experience, but obviously, if you're interested, you should definitely read more. I encourage you to read more on what is the situation of compliance with provisional measures. So that's the structure of the United Nations Charter, which is, I would say, the place to start when you think about the ICJ. So I think it would be important for you as you prepare for your Jessup, experience generally, to go over the rules of the Charter in Articles 91, 92, 93, and 94, and be aware of what are the rules, also because they can help you to answer questions that are posed by the judges. Now, the second big instrument that is relevant for us is the Statute of the International Court of Justice, right? And the Statute of the International Court of Justice is the treaty which establishes the court and regulates its basic functions of the court. Now, apart from the Statute of the ICJ, we also have the Rules of the Court. The Rules of the Court are a more detailed document where the more specific functioning of the court is laid out. So let's say what happens in written proceedings, what happens in oral proceedings. And what's different is that the statute of the ICJ is a document that is very difficult to amend. You would need the same quorums to amend the Charter of the United Nations, because the statute of the ICJ really establishes the very broad rules by which the court works. For example, rules on jurisdiction, or rules regarding the amount of members of the court, the amount of judges, right? The rules of the court can be amended by the court itself. In fact, the rules of the court have been amended several times because they have much more to do with the functioning of the court on a case, on a more procedural basis. So it's the functioning of the court with respect to the managing of cases. And therefore, obviously, it needs more flexibility. Now, for you, I would say that the statute of the ICJ in the Jessup experience is a very important document. I do think that I would really encourage you for you to read and be aware and be knowledgeable on the statute of the International Court of Justice, because issues might arise and the answers to which you will find in the statute. The rules are less relevant because they have much more to do with how the court in the real world functions, with respect to the specific cases. So in that sense, I think that it's not going to be that useful. You can always check them, but it's going to be really more about what state parties are expected to do when they're facing a real case in the court. But the statute is important. Now, when it comes to the statute, a good place to always start is Article 34 of the statute, which establishes that only states can appear before the court. This is an absolute rule and which you cannot forget. So if you're not a state, you cannot bring a case before the court. It is different when it comes to advisory opinions, because in advisory opinions, international organizations are allowed to participate. But the advisory jurisdiction of the court is a completely different animal from contentious cases. When it comes to contentious cases, if you want to bring a case as an applicant, you have to be a state, and as an applicant, you can only bring a case against a respondent, which also has to be a state. And this is very clear from Article 34 of the Statute of the International Court of Justice, in Article 34, paragraph 1. Then Article 35 says that the court shall be open to the state parties to the present statute. And as I told you before, if you're a member of the United Nations, you are ipso facto a member of the statute. So that's not really that controversial. And then we come to Article 36, which is perhaps one of the most important articles of the court, of the statute of the court, because it establishes the jurisdiction of the court. So whenever you are dealing with questions of whether the court has jurisdiction to entertain a claim, Article 36 is where you start. This is the cardinal rule to determine the jurisdiction of the court. So here it says that, so paragraph 1 says the jurisdiction of the court comprises all cases which the parties refer to it, and all matters specially provided for in the Charter of the United Nations or in treaties and conventions in force, right? So this is the broad jurisdictional clause of the court. Now, what does this mean? That there are essentially, under Article 36, paragraph 1, there are essentially 3 ways in which you can bring a case to the court. One is by by concluding a special agreement, or what in French is referred to as a compromis, between 2 states. 2 states come together, they decide to sign an agreement, and pursuant to that agreement, bilateral agreement between 2 states, they decide to submit a dispute to the court. That is something that happens a lot. Actually, there are several Jessup cases in the past that have granted jurisdiction to the court through a special agreement. If you go back in the Jessup practice, you'll see that instead of having a statement of agreed facts, you're going to have a special agreement or a compromis. And basically what the Jessup is telling you there is that the way in which the 2 states gave jurisdiction to the court was through a special agreement concluded for the purpose of asking the court to resolve that dispute. So that's road number 1, right? Special agreement or compromis bilaterally signed by 2 states is a treaty, common bilateral treaty, by which you give jurisdiction to the court. The second one is when you have multilateral conventions for the purpose of the settlement of disputes. So these are treaties that are usually regional treaties, and they grant jurisdiction to the court to very broadly resolve disputes between those states located in a region. So, for example, the Pact of Bogota is an example of that. So the Pact of Bogota is a multilateral treaty between the states in Latin America. And the object of the Pact of Bogota, the object and purpose, is the peaceful resolutions of disputes. And it establishes that states in the region are able to submit disputes to the International Court of Justice, and the different states of the region recognize the jurisdiction of the court to be able to submit that case. So that is a very broad jurisdictional instrument. And if you see, for example, the nature of the cases that have been brought by Latin American states to the International Court of Justice, they are extremely different in terms of nature, because the Pact of Bogota is a broad treaty for the peaceful settlement of disputes. Now, the third mechanism is when you have a multilateral convention on a subject matter, and there's a compromissory clause in that treaty that provides that if there are any disputes regarding the interpretation or application or fulfillment of the obligations under the treaty, then the International Court of Justice will have jurisdiction. So a typical case of this is the Genocide Convention, right? So the Genocide Convention establishes the obligations of states to prevent genocide, and not to commit genocide. And then the compromissory clause, which is Article 9 of the Genocide Convention, establishes that if there are any disputes regarding the interpretation, application, or fulfillment of the obligations under the Genocide Convention, then those states can go to the International Court of Justice. Something similar happens to the Convention Against Torture, or the Convention Against Racial Discrimination, the Convention Against the Discrimination Against Women, CEDAW. These are all multilateral conventions which are subject specific, and they have a compromissory clause that grants jurisdiction to the court. So these are the three ways in which states usually grant jurisdiction to the court. So special agreement or compromis, very broad treaties for the peaceful settlement of disputes, usually at a regional level. And then third, multilateral subject-specific conventions that award the court, that give the court jurisdiction for the interpretation, application of those specific obligations. Now, with that all comes from Article 36, Paragraph 1. Now, Article 36, Paragraph 2 establishes the compulsory jurisdiction of the court, which is when a state files a declaration recognizing the compulsory jurisdiction of the court in its disputes generally. So there are many states that file these unilateral declarations, and they tell to the court, well, you know, I am giving the court jurisdiction to settle any disputes concerning my state. Now, usually these declarations recognizing the compulsory jurisdiction of the court are not absolute. They are always subject to a condition of reciprocity, which means that the two states involved in the dispute have to have filed these declarations accepting the jurisdiction of the court. So let's say, for example, if a state like Chile wanted to take a state like Argentina to the court in a hypothetical scenario, then if Chile wants to bring this case, then not only Chile would have needed to file this declaration of compulsory jurisdiction, but Argentina would have needed to do the same. So only if the two declarations are reciprocal, then it's possible to for the court to have jurisdiction. And states also, when they file these declarations, they establish limits to the jurisdiction ratione materiae and to the jurisdiction ratione temporis of the court. So by filing these declarations, they usually say, well, we are okay with the court entertaining disputes on these issues, but we want to exclude from the jurisdiction of the court these other issues. So that would be material limitations to the jurisdiction of the court. And sometimes states file these declarations and say, well, you can only entertain disputes with regard to facts arising after this date, which are temporal limitations to the jurisdiction of the court. So when they file these unilateral declarations, states are pretty much free into kind of drawing the limits of how much they want the court or how far they want the court's jurisdiction to go. And as I said, because there is a principle of reciprocity, then the court is going to basically have to look at the two declarations of the two states and then figure out whether there is an overlap. And only if there is an overlap, then the court will have jurisdiction. So the court needs to be sure that there is complete reciprocity between the two states in order to establish its jurisdiction. Now, if you're interested in, going around these declarations and seeing, what they say and what kind of reservations states make with respect to these declarations, they're all published on the website of the court. So on the website of the court, you have the entire list of countries that have deposited unilateral declarations accepting the compulsory jurisdiction of the court, and you can read them and figure out if you like them or not. So that's Article 36 essentially. Now let me go to Article 38 of the ICJ statute, which is where usually we find the sources of international law. Now, it's important for you to always read the first paragraph of Article 38, which says the court whose function is to decide in accordance with international law such disputes that are submitted to it. So here is where the function of the ICJ is defined, right? So the function of the ICJ is to decide disputes in accordance with international law. That's what the court has to do. The court is not tasked to do anything else beyond that. So it's important that when you are also preparing for the Jessup, you keep in mind that what the court is being asked is to decide a specific dispute submitted by two states in accordance with international law. And that's as far as the competence of the court can go. Now, then in letters A to D, you have the sources of international law. So you have conventions, costume, general principles, and the teachings of highly renowned publicists and jurisprudence and decisions of tribunals, right? Now, the first three, and I'm sure you had another lecture on sources of international law, so I'm not going to go deep into that. But it's important for you, and this is also a very important part of the Jessup exercise, in my view, is that when you present arguments, it's important to know what source of international law, what source in Article 38 you're asking the judges to apply. So are you making an argument based on a treaty? Are you making an argument based on costume? Or are you making an argument based on general principles? And it's extremely important, and this is an advice that I give to all of the teams that I have coached, and also every time I've been a judge, that whenever you craft an argument, always be sure of what is the source of international law that is involved in that argument. Because you need to be able for each argument to identify whether you are in Article 38, one letter A, letter B, or letter C, right? Now, you can never only rely on letter D, because the letter D is a means for the determination of the rule of law, right? It says, letter D at the very last part of Article 38, one letter D says, there are subsidiary means for the determination of the rule of law. What that means is that the teachings of highly renowned publicists and the jurisprudence of the court are important when you are interpreting treaties, costume, and general principles. When you're trying to explain to the court why the treaty should be interpreted in this way, or why the treaty should be applied in this way, when you are explaining to the court why customary international law exists or doesn't exist, or what is the actual scope or the content of the rule of costume, or when you're explaining the interpretation or the existence of a general principle, then you can use publicists and jurisprudence as you are explaining that, as you are interpreting, as you are determining the content or the scope of the rules of the sources of international law. But for every argument you make, it's very important to know whether you are on the path of treaties, on the path of costume, or on the path of general principles. And I think that's going to help you a lot as you think through any Jessup problem, but also if you are ever, arguing before an international tribunal at the ICJ or other international courts and tribunals. I think it's extremely relevant always to know which source you are pursuing. And that's, I think, all I'm going to say about the sources of international law, because I think I have another lecture where you're going to go into the specific, although obviously if you have questions, I am more than happy to answer. Now, paragraph 2 of Article 38 establishes the power of the court to decide ex aequo et bono. And what you need to know here is that this is only the parties agree. So Article 38.2 will only be relevant if the parties agree that the court should decide in that way. Now, those are, in my view, the most important. I'm going to go to Article 59. And there, I think I'm going to stop because I want to see if you have questions, because no one is jumping yet. So Article 59 is another important article of the Statute of the Court, which establishes that the decisions of the court have no binding force except between the parties and in respect of that particular case. So this goes back to when we were talking earlier about Article 94, paragraph 1 of the United Nations Charter, which establishes that states undertake the obligation to comply with the decisions of the ICJ. Well, Article 59 of the statute also tells us that the decisions of the ICJ are binding, and therefore it's not voluntary for them to decide whether they comply or not. But they're binding with two carve-outs, right? One, they're only binding between the parties of the case, so they don't have any generalized effect with respect to the other states in the international community. So they're only binding on the two states, the applicant and the respondent. And the second is that they're only binding in respect of the particular case. So beyond that case, even if it's the same states involved, it would not be binding. So it's constrained to the parties and the case. And this is very important to know in terms of the reach of the decisions of the International Court of Justice. This also explains why the International Court of Justice doesn't follow a system of precedent like common law jurisdictions do, for example, in the United States. So the court relies heavily on decisions by the International Court of Justice and even other international tribunals, but it does not have an obligation to follow its jurisprudence. So the court could potentially change, could break from its jurisprudence, could break from its tradition. It's extremely unlikely that it's going to happen. The court will always make its best effort to follow the case law, but the court, strictly speaking, does not have a system of precedent.